All right, while our panelists are getting settled, I'd like to make note that it is 10:38, and we are starting right at 10:38. For those of you who are joining us on the web, thank you for participating as well. For this panel, we're going to talk about some potential policy solutions or options for improved off-label communication. This panel is going to draw on some of the options presented in the paper that was released by our working group today. You heard from some of our working group members like Rich Shilsky on the last panel. There are others who contributed who are listed on the author list. But right now, looking forward to hearing from three of those working group members to highlight some of the important elements of the paper. This includes Colleen Klassmeyer, as I mentioned before, as a partner at Sidley and Austin, Mark Scheinson, a partner at Alston Bird, collectively two of the very well-known legal minds in the area of food and drug law, and Peter Pitts, president of Center for Medicine and the Public Interest, who has a long history of working on communication issues, including at the FDA, directing communications there. Each of these panelists are going to highlight two of the most important elements of the white paper that they helped to develop. That's a set of the guiding principles that potential policy fixes should use as guideposts, and a range of policy options that were presented in the paper as well. So I'll start with Colleen, who's going to walk through the paper's discussion of principles in this area.
Thanks, Mark. I want to start by thanking everybody at Duke Margolis for convening this opportunity for all of us to get together and discuss what is an incredibly important public health and legal issue. I also want to just mention that all four of us have in common that we worked at FDA. And so one of the touchstones that you'll hear us talking about as we describe the guiding principles is really a conviction that FDA is the preeminent global juror for information about drugs and medical devices and other products. And it's one of the more vexing and intriguing aspects of the policy discussion, the continued role of FDA in regulating manufacturer involvement in communications about off-label uses. But we all, I think, having worked at the institution, have an abiding love for it and a deep commitment to making sure that the agency isn't left behind as the policy debate continues. The working group met by phone and in person a number of times over the last several months, and we thought for a nanosecond that we could possibly identify one enduring solution to this problem, and then we all realized that that was foolishness and decided that the best we could do is identify a series of guiding principles and a number of policy options. And there are many, many options beyond those set forth in the paper, and there are variations on the options as well. But the guiding principles really describe the analytical substrate for the policy options that we put to paper. The guiding principles are as follows. First, to promote well-informed clinical decision-making to improve public health. So in an earlier draft of the paper, we had public health kind of woven throughout the various guiding principles, but ultimately decided that the paramount policy objective for all of these discussions is to protect and promote the public health. And as Peter and Mark will tell you, there's a magic behind that phrase, and it refers to the two different dimensions to the off-label policy discussion in the following way. To promote the public health, you need to have adequate information out there to support unlabeled uses, and that creates a need for FDA's regulatory scheme to allow manufacturers to have alternative channels to provide off-label information, alternatives to promotion. To protect the public health, there needs to be enough of a brake on manufacturer dissemination that you don't have indiscriminate off-label use in a way that harms patients. So that's the delicate balance, and indeed delicate balance is the phrase that FDA has used for years now to describe the policy objective for FDA's own safe harbors and the way the FDA itself administers the law. We didn't really have any disagreement over the importance of public health as the primary touchstone for our discussion. I think the disagreement agreement, not just in the working group, but more broadly in the public health and legal community, is which policy solution strikes the right balance, which policy solution does the best job of both protecting and promoting the public health. The second guiding principle is really designed to get at what role for FDA. There are some people in the broader policy debate, although I didn't hear anybody on the working group articulate this view, but it is out there. There's some people who think that FDA really should play no role as a censor or an evaluator or a juror or an adjudicator of efficacy claims for drugs and medical devices. One way of thinking about this question that isn't quite so, in my view, extreme is to ask to what extent should claims about drugs and medical devices be subject to FDA prior review at all. So it's a question of extent, not a question of whether FDA has a role in prior review. It's really where do you draw the line between claims that are subject to prior review and claims that are not subject to prior review. So for example, we talked in the last panel about clinical endpoints that are used as a basis for building an economic model to deliver some kind of information about not just clinical but also economic consequences. Should clinical endpoints that are used in those models be required to be on label? And in other words, should FDA have the entitlement to review a manufacturer's discussion with a payer about an economic model that's built on an unlabeled clinical endpoint? So one example would be, let's say you have an injectable long-acting antipsychotic. It's approved based on data showing that it relieves symptoms, but no data showing that it reduces hospitalization among patients with symptoms of psychosis. Should the manufacturer of that antipsychotic be able to create and talk about with a payer an economic model that makes some reasonable judgments based on data to the extent possible about the degree to which that product will in fact reduce hospitalizations and therefore deliver favorable economic consequences to the plan? The third guiding principle has to do with coordination among arms of government, a perennial challenge. DOJ, of course, represents FDA in court, and there are other entities involved in regulating the role of manufacturers in off-label speech and enforcers, including the states and the relator bar, qui tam plaintiffs, and the like. There are significant public health considerations, as we've been talking about, associated with where you draw the line between prohibited and permitted communications about off-label uses. And one of our guiding principles is that whatever enforcer or regulator you're talking about, there ought to be some reliable mechanism for making sure that enforcement decisions take adequate account of the public health. We thought the best way to do that is to make sure that all regulators and enforcers talk to the experts at FDA to make sure that, for example, if DOJ brings an investigation that alleges a manufacturer committed a violation because of speech relating to, for example, first line versus second line use, does it really make sense from a public health standpoint to chill speech about first line use for a product that's only labeled for second line if there's really good evidence to support use of the product in the first line? And in fact, it could be the standard of care. We also, relatedly, talked about the importance of coordination within the government, not just on public health considerations, but also legal and regulatory considerations. And the observation here is that sometimes you could have an FDA policy that affords a safe harbor, but DOJ won't necessarily recognize the same safe harbor. And immediately following the Coroni decision, some of you may remember some folks from DOJ took the podium, and one very senior DOJ official said, well, of course, DOJ would never commence an investigation or an enforcement action against a company for engaging in conduct that was safe harbored by an FDA policy. Several days later, a different senior FDA official took the podium and said, FDA guidances are FDA guidances, they're not DOJ guidances, and so we would make our own independent decisions about whether to bring an enforcement action or an investigation without regard to what FDA's own policies might be. Having that sort of dislocation contributes to the instability in the regulatory scheme, and we think has some implications for the public health. The fourth guiding principle, certain things we think would reduce the litigation risk for the U.S. government and would improve the stability and sustainability of the scheme from a public health and legal and regulatory standpoint. Lawyers tend to think of litigation as a perfectly legitimate dispute resolution mechanism, but I think all of the lawyers in the working group agreed that it's probably not an ideal way to evaluate the incredibly complicated regulatory and scientific and patient care issues that are often raised by these kinds of scenarios. And so one of our guiding principles is that we should do what we can to avoid continued cycles of litigation, and that to us felt like an opportunity to provide greater clarity in the applicable regulatory policy. And finally, in terms of promoting more evidence generation and data submissions to FDA, this is essentially the real-world evidence point that everybody was talking about in the opening panel and that Mark discussed. I mean, what do you do about these non-registration quality sources of data, sometimes Lucy referred to as real-world evidence? You could have non-clinical data that could be incredibly useful in evaluating the clinical utility of an antimicrobial, for example. You could have data organized according to genetic variations. And none of these data would be permissible for use by manufacturers in proactive promotional communications, but might be really, really important to support clinical decision-making and population health-based decision-making. We talked about including a new section in labeling to accommodate this kind of real-world evidence, which raises a whole host of legal and policy and institutional issues. But the bottom line is we really thought one of our guiding principles ought to be that any changes made, any policy proposals advanced here ought to promote more evidence development and data submission to FDA because, as Rich mentioned on the last panel, it's critically important for payers and providers and patients who rely on this information to have some external indicia of reliability as to that information.
Great. Thank you very much, Colleen. A concise summary of a lot of complex issues. Turn to Mark next.
Great. Thank you, Mark, and thank you for this opportunity. This is definitely an assemblage of great scientific, legal, and policy minds focusing on this one topic that we've all been wrestling with for probably our entire legal career. Thanks also to Mark and the Duke Margolis Center for sponsoring this dialogue. So we do want this discussion to be interactive and hope you'll have questions as we get done sort of with our observations. I just want to focus for a minute on getting clarity from FDA on some of these key concepts and then trying to get consistency between agencies, particularly DOJ and OIG and FDA in this space. This is definitely a lawyer's full employment act, and I don't want to discourage that. But probably from our pharmaceutical and device clients, we get more questions on marketing and promotion and whether communications are off-label use and on any other issue that we deal with. Part of that is to act as arbiters between, as outside arbiters between regulatory affairs and marketing. So we can be the bad cop in certain times or find ways to do things that might not be as risky as others. And part of it is just because it's hard to find where the law is. It's such a patchwork quilt of some very old regulations and 201 and 202 for labeling and advertising. Some guidances, some of which are still in force, some of which have been withdrawn, some of which are coming soon. And the law on off-label use is pretty simple, but you can't find it in one place. So we use I use an analogy of a four-legged stool. The basic law is there are four situations in which a company, a manufacturer, or someone acting on their behalf is allowed to give off-label information. You've heard of some of these. If the information is supported by substantial evidence, you can always use it. And substantial evidence doesn't always mean that FDA has had to review it and opine on it. Of course, if you're going to use that information, you've got to be ready for FDA to review and opine on it. And if they've already seen it and discarded it, it's very risky to do that. And they're the masters of shredding clinical evidence. The second is, an FTC uses a different standard, which makes it even more confusing. It has to be competent and reliable. And there's a memorandum of understanding between FTC and FDA. FTC gets to be in charge of advertising for OTC products, for instance, and FDA is labeling and advertising for RX products. But it's a different standard. And the law also for pharmacoeconomic claims, whatever that is, it uses that competent and reliable claim or standard, which is different than substantial evidence. The second is scientific exchange of information under the 312.7 rules. None of these rules are intended to restrict the full exchange of scientific information concerning drugs or devices, including dissemination of scientific findings and scientific or lay media. So that generally is CME or scientific meeting, but the world has gotten a lot more complicated, and lots of people don't go to Washington and risk planes flights in winter. They might see it on a satellite feed or online, and is that within that dissemination exception. The third is unsolicited requests for information by prescribers, and FDA has some guidance on that. But if it's unsolicited and the prescriber that you're detailing happens to ask you, is there anything out there that I haven't seen that I should know about? That's generated the whole industry of medical scientific liaisons. So you don't have the marketers answering those questions, but you have somebody that's scientist to scientist answering the information. And the fourth exception we know about is the Washington Legal Foundation line of cases, or good reprint practices, where you can disseminate peer review or journal articles as long as the drug has been approved for something, found safe or effective for something. This information should be put together in one place. I mean, if off-label use is legal, why isn't it simpler to figure out what the parameters are for that? And we can all speculate. Colleen, while she was at FDA, maybe counseled. I don't know, but sometimes ambiguity is favorable, and it's hard to draw these lines. And there is. But it does create a chilling effect when it comes to constitutional law evaluation. We could use from FDA answers to questions of, what is a pharmacoeconomic claim? There's a big, long guidance on how to create a clinical trial for quality of life claims, but that doesn't do it. We could use an answer to the question of what's false, lacking in fair balance, or otherwise misleading. That's the standard the courts created in Ameren and in Coronia and in other cases. Well, what does that mean? FDA has some regulations in the advertising regs giving examples of false or misleading. That should be promoted, highlighted, discussed. What is labeling versus advertising, and why does it matter? All those issues are out there. What is promotion? What's promotional labeling? Is disease management information that just talks about a disease but doesn't link it to a specific named therapy? Is that promotion? FDA's opined at times that it's not, but then the disease management guidance has been withdrawn. So it's very hard to counsel in this area. How do drugs and devices and their rules differ? I mean, the question was just asked, and that could be a separate course here for an hour or so on how device rules differ from drug rules. And every device company I've seen does it a little differently. How do you expand the use of physician clinical practice guidelines? Those have emerged as the primary source of off-label prescribing, and they're meta-analysis, they're peer-reviewed, it's really good data, but FDA views that it doesn't rise to the level of substantial evidence, so it's not the same level as on labeling. The other thing lawyers are used for is to generate what we in the trade call rat letters. You shouldn't need to so marketers say that if you're not going to do this, or if you're going to, if you're not going to let us say this information, make our competitors stop, level the playing field. And, it's a self-policing system where a lot of law firms kind of spoon-feed FDA in a, confidential way that other competitors are doing this, and this should be stopped. And that generates a lot of the enforcement activity that occurs. Also, organizing the warning letters and the notice of violation letters would be a great thing for FDA to do. Anybody that's tried to review those letters by subject area or by issuing office, OPDP, if in this realm, has a hard time putting that together. But those warning letters or notice of violation letters are as important in this gray area of off-label promotion as anything. So just a couple words, too, on greater clarity and consistency between agencies. People that are policy areas or giving legal advice know the 800-pound gorilla in this space now isn't any longer FDA, part of which is they're not issuing that many warning letters or notice of violation letters in this area, despite the pleas of competitors. It's OIG. It's off-label promotion now is a federal false claim for reasons that I still can't wrap my head around completely. I mean, the implication is that if you're going to promote for this use, you should anticipate that physicians or patients are going to try to get reimbursed for areas that might not be reimbursable. But, you all see, 5 or 6 cases a year that are over $1 billion sometimes, hundreds of millions of dollars in settlements because nobody wants to risk being excommunicated or, suspended from the Medicare system or the use of the Medicare system or Medicaid or federal health system. So those, are huge. The OIG has been good. It's had a compliance program guidance for years on pharmaceutical manufacturers talking about the criteria that they use in order to take a case. But key TAM relators are, that's better than winning the lottery. I mean, they're multi-million dollars, tens and sometimes hundreds of millions of dollars, and keeping a third or of what might be granted by the court as damages or in settlements. So that's a large incentive. There's confusion. If it's okay to promote off-label for FDA, should that be a grounds for a federal false claim? Can't these agencies get together and communicate? Mark McClellan, would be the ideal candidate to talk about how.
I don't know about that.
How to get them to talk to each other and to have common systems. So, those are the issues that we tried to at least highlight in this report and try to offer some alternatives. Thank you.
Great. Thanks, Mark, for that perspective on the policy options discussed. And I'd like to turn to Peter to talk a little bit further about the policy options. You want to come up here? All right.
Again, I'd like to thank Mark and the Duke Center and the staff that do a tremendous job. Relative to Mark's statement that key TAM is better than winning a lottery, I don't know whether that's true, but it certainly is a lot more fun. It's important to say, I think early and often, that almost no one here or within the context of our conversations as a working group is against sharing valuable information about FDA-approved medicines. The heated discussion, is over how or if that conversation should be regulated by FDA. The debate over off-label communication doesn't begin or end with Cronia or Amarin decisions or any decision. It's a continuing dialogue between manufacturers and the FDA, between doctors and patients, between payers and economists, between lawyers and judges, and between advocates on all sides. And the red thread that ties these conversations together is responsible off-label communication. Not sales strategies, not DTC tactics, not managed market negotiations, the responsible sharing of truthful and accurate information. Steve Jobs said, "Innovation distinguishes between a leader and a follower." And make no mistake, off-label communication is about innovation. Innovation in the safe and effective use of FDA-approved medicines. Off-label communication is about getting the right medicine to the right patient in the right dose at the right time, even though the right medicine or the right dose may not correspond precisely to the FDA label. But who is the leader and who is the follower? Or perhaps a better question to ask is, why can't we all be leaders? Off-label communication is about recognizing that the speed of scientific discourse impacts clinical practice years before it drives official label changes, if at all. So what do academics and physicians, payers and patients know about off-label communication that the FDA does not? Asked in a more progressive way, how can the FDA be an accelerator rather than a sea anchor when it comes to facilitating off-label communication? In a word, the answer is clarity. Consider the FDA's guidance on clinical practice guidelines. Any CPG that includes information on unapproved or uncleared uses must meet IOM standards, Institute of Medicine, for whether it is a trustworthy guideline. According to IOM, a guideline is trustworthy if it is based on a systemic review of the existing evidence, is developed by experts in the subject area, considers important patient subgroups and patient preferences, is transparently developed and funded such that biases are minimized, provides logical relationships between treatment recommendations, health outcomes, and includes the quality and strength of the underlying evidence, and finally, is recognized and revised as new information becomes available. Now let's consider the final two policy options in the paper in front of you today. Revisions to efficacy claims or product labels. One approach is to maintain the high standards for incorporating evidence within a label, but with a clear recognition that lower levels of supporting evidence can be communicated within certain circumstances or to particular audiences, effectively allowing for a broader scope of communication that uses the label and additional sanctioned evidence as its foundation. More on sanctioned in a moment. A more extensive policy shift would involve including additional clearly delineated tiers of evidence into the product label. Primary efficacy claims and information for an approved indication would be given the most weight and highest placement, but additional evidence with appropriate qualifications could be added to the label as a greater body of evidence is generated on the product's use in different contexts based on real-world evidence. This approach would not in any way alter the standards for approval of a primary indication, nor alter the existing standards for labeling expansion. But it would recognize that additional evidence that does not meet those standards is being used in patient care and could benefit from ongoing review and interpretation by the FDA. This is in keeping with the agency's role in providing important information to physicians without attempting to regulate the practice of medicine. These proposals are intended to be in line with other FDA efforts to enhance the development and use of meaningful evidence derived from real-world practice. For example, a pilot program might enable a provisional claim related to an additional indication based on limited evidence, provided that a reliable infrastructure like the Sentinel system be used to further develop evidence on that indication. Congress may potentially need to be involved to make changes in statute or provide appropriate user fees to support clearer guidance and faster action on these issues, because we haven't really talked about PDUFA today. In any case, such efforts are critical for promoting the development of more evidence on a wider range of key treatment choices and for keeping the FDA's expertise constructively engaged in the development and use of such evidence. If the FDA leads, as Colleen said, the world will follow. Next, third-party sanctioned communications. An alternative, and one that does not have the universal support within our working group, involves a more intramural approach based on the FDA's partnering with an external entity charged with accrediting certain types of communication. This organization could focus its efforts on reviewing not an NDA, but an NDI, new drug information, or new device information, consisting of a sponsor's evidence and associated communications about off-label use, and then potentially approve them for broader distribution. An NDI review could be given a rank, score, or grade system that confers greater weight to better evidence and could be given contingent upon continued evidence generation and resubmission to the clearing body. For example, an off-label communication may be approved and given an initial grade or rating that sunsets within a specified number of years, barring updated submission of relevant evidence. Continued off-label communication at the current evidentiary grade after the specified date would then be subject to additional evidence development by the sponsor. The proposed reviewing body would operate outside of FDA, but with FDA participation. To avoid First Amendment and other legal concerns, the body's conclusions could not bind the FDA or otherwise hinder FDA's ability to pursue enforcement action. While the reviewing body would not provide certainty to the regulated community, its recommendations could offer useful guidance to drug manufacturers. An approach that involves an outside reviewing body might enable FDA to advance a model that more clearly differentiates between types and levels of communication without modifying the FDA-approved product labeling. For example, the reviewing body might treat communication around off-label use that has become standard of care in a different manner than more tailored or less well-established evidence on an off-label indication or within a specific patient subpopulation. Such a system could potentially play a more directed and focused peer review alternative or supplement to the current role of peer-reviewed communications. Any such entity will need to have participation from the FDA and potentially other relevant agencies, as you've heard earlier on this panel. Incentives in the form of more rapid and predictable review and action would need to be in place to encourage sponsors to develop evidence and submit communications materials. The end goal would be a process that augments the FDA's capacity to review a diversity of communication types reflective of rapidly emerging evidence, but does not change the FDA's ability to pursue enforcement action. All this to say that off-label communication is now on the health policy front burner, and the flame is on high. As Everett Dirksen used to say, when I feel the heat, I see the light.
All right, Peter, thank you very much for those comments. I'd like to expand the discussion now to include reactors to the presentations in the paper. So if our reactors would come on up to the stage, I'll introduce you while you're coming up. Dr. Josh Sharfstein, I think many of you know, he is currently the Associate Dean for Public Health Practice and Training at the Johns Hopkins Bloomberg School of Public Health. Formerly, Josh served as Secretary of Health in Maryland, and before that as Deputy Commissioner of the FDA. So, like just about everybody else on this panel, has direct FDA experience, and in Josh's case, a very senior leadership position. And Michael Lisgarten is the Senior Associate General Counsel of Genentech, where he's very much involved in many of these issues as well. So, Josh, Michael, thank you all for joining us. I'd like to turn to you all now for some initial comments, then we're going to open this to a discussion with the group and with the rest of the audience here. Josh, do you want to start?
Sure. Thank you. Thank you for inviting me. I appreciate it. I possibly may be like in the Sesame Street, which one of these is not like the other to a little extent, but I appreciate the interest and the diversity of opinions on this topic. I want to just organize my comments around the document, which I thought was very thought-provoking, and I'll go through the parts that I agree with and maybe the parts that I don't. To start, I would probably say that this kind of effort would benefit from a section on history and evidence, because it isn't just a legal discussion. It isn't just a kind of policy argument from first principles. There's an awful lot of history that goes with off-label use. I would include in that section why we even have limits on off-label promotion, the history of that, going back to the 1962 amendments that established that drugs had to be safe and effective for particular purposes, and the thalidomide problem, which really spurred that. And in fact, when they looked at off-label uses and uses that were being marketed, thousands were considered to be without evidence at that time. I would include in that section evidence of problems with off-label promotion. I think it's important to distinguish between off-label promotion, which is really what this issue is about, as opposed to off-label communication. I don't think anyone here, certainly not me, would have a problem with any type of journal publication, report that is talking about off-label uses. There are thousands of those papers. There's a robust exchange of ideas there. We're talking about the ability of a company with the financial interest to be promoting that here. And there's a lot of evidence about that. There's evidence of abuses where patients were seriously harmed, I think there was behavior that none of us here would defend. There's evidence that it increases the cost of care in many situations, which is a very important outcome. There's evidence that people who engage in off-label studies don't disclose their relationship with companies and mislead people. And there's evidence just in general that when in that promotion space, there are a lot of examples of companies stretching the truth in ways that are actually averse to patient interests. And then the third area I would include in that first section would be a little bit more insight into what's happening with the cases. The cases aren't coming, totally from on high. There's a new approach to the First Amendment that's been evolving. In what I would draw attention to is the fact that judges are taking over FDA roles in assessing whether something is accurate or misleading. And if they're doing that, there's nothing that FDA can do. There's no line that FDA can draw that a judge won't say, actually, I think this isn't misleading. And in fact, if you look at the Ameren decision, I think there was a very unwitting point there where the judge is saying FDA got it wrong. The judge is totally wrong in how he reads the sentence and the evidence, but it's tough for FDA. When the judges take over, there's nothing the FDA can do. I think those are three really important areas of context. So then moving to the principles and the policy. I'm now the Associate Dean at a School of Public Health, first School of Public Health. We're having our centennial year this year. Let's just say that that's not something that is under the radar screen at the school. You drive by Baltimore, there's a big 100-year sign. It's on all of our slides. You go back to 1915, the report that set up the school. Interestingly, John Rockefeller was thinking of funding either Harvard or Columbia, and he hired the Johns Hopkins Dean of Medicine to advise him on whether to support the first school at Harvard or Columbia. And he was sort of like the original Dick Cheney search right there, wound up at Johns Hopkins. And at the time, that paper said that public health, the unity in public health is to be found in the end to be accomplished, the preservation and the improvement of health, rather than in the means essential for this end. Another definition of public health that's worth mentioning is the Institute of Medicine's definition from 1988. What we as a society do collectively to assure the conditions in which people can be healthy. So if we're talking about the goal of this being public health, it's got to relate to people's actual health. That's what public health is, and the health of the community. That is always been the definition of public health. So now you look at the principles, and I agree with a number of them. I agree that it's critical that evidence be developed on drugs to know whether or not they work. That is the core aspect of, if you're a patient, you want the evidence to be there, to have been, the studies to have been done. That's a really important principle that's directly related to health. I think we all agree, and we heard that, and it's in the report, that FDA's central role, very important for public health based on the incredible role FDA has played over the last century. And I agree with clarity. I think it's easier said than done. If Mark wants to take that on with all the different agencies, I'm more power to him. It's a very difficult job because everybody does feel it's their own law, their own area. It's very hard, but I agree with what's in the report there. I would add a principle that whatever policy on off-label use should be minimizing the harm to patients from inappropriate promotion, because that has happened. It's very important to have that as a goal, and it directly relates to public health because you have large groups of patients who've been hurt. The issue that the first principle in there is about promoting good information, which I'm not opposed to promoting good information, but I think it's a question, maybe more than a principle, the extent to which promotion really does promote good information. And I'd be very interested in understanding what data is there on that, because I'm certainly aware of data to question that assumption. Now going on to the policy, I agree with the policy recommendation on clarity, as I said before. I don't think the policy recommendation on this extra section of the label is very compelling for a couple reasons. One, I think it kind of just lowers the bar generally. I don't think it's consistent with really supporting the FDA's role. But the other thing is I think it's probably practically impossible, because if you have a section that is based on other data that's out there, and every week there are 50,000 more studies coming out, every single day on like every single drug, someone's going to be angry that that thing hasn't been updated. And I think it's just miserably hard for the FDA to keep up from that. And I would really, think that that would just be a horrible assignment to be responsible for that at FDA. I don't think you can credibly say that you're supporting the role of FDA by allowing third-party people to permit marketing. I just don't think that's a credible position. I think if we agree that the fundamental role of the FDA is critical to public health, you can't let other people call the balls and strikes. I would add, let me just say, I think I've appreciated the points that are being made about economic issues that could come up. And I think that the principle that's out there that companies can respond to inquiries is a good one. And I would apply that to the economic discussion. I mean, if my hospital system is interested in the evidence on something, the company should be able to give it in response to a query. I don't have a problem with that type of exchange at all. I think FDA has drawn some reasonable lines in that regard. But I don't necessarily think that there's a class of evidence that should be promoted unless there's evidence that suggests it's really needed to be promoted. Finally, I would add a couple other policies. One is I think that it is very important for companies to stand down in suing the FDA. If the judges are going to be totally unreasonable and substituting their judgment, it undermines the whole enterprise for everyone to keep going back and suing. I don't think it's wrong for companies to argue with the FDA what the right standard should be, but I think there has to be some deference to the agency. Otherwise, you have the problem that there's just no line FDA can draw, and what you wind up is kind of a Tower of Babel in the marketplace. And finally, I think it's appropriate for any paper on off-label use to say to judges, be very careful substituting your judgment for the FDA. You make mistakes like the Amarin decision. You basically make it impossible for any company not to wonder whether they might be able to say something just a little bit different and get through by any judge who could read that differently than the FDA. It's not hard to find a doctor to say something. You could put I found a doctor that thinks this drug is great for this other thing, or this paper says that or the other. And the only thing keeping us in a reasonable semblance of communication from companies is the FDA. I would just end with this last point, which I think is important because I find myself maybe a little bit out on one of the extremes of this discussion, particularly perhaps in a room like this. But I would just point out that the 1962 amendments and the restrictions on off-label promotion coincided with the absolute golden age of the pharmaceutical industry. When FDA sets the standards and people believe in the FDA's reviews, that allows companies to make great drugs, do the studies the patients need, and get very well rewarded for them. And I think it's penny wise and pound foolish for companies to be pushing and supportive of a type of litigation that ultimately may make it very hard for people to distinguish between the wheat and the chaff out there. Thank you.
Josh, thanks very much for the thorough comments. I really appreciate it. Next, would like to turn to Michael.
I'd really like to thank the Duke Margolis Center for raising this topic and having this forum, because I think it's, I've been working on this issue for a while in connection with the Medical Information Working Group, and sometimes it just seems like this issue is teed up as an industry versus FDA issue, and I really don't think that's the case. And I think we've heard, from Dr. Shilsky, the physician interest, from the patient interest, and I think even with Josh just sitting here and saying one of these is not like the other, there's a surprising degree of convergence of interest and opinion, even with industry. I think industry is not monolithic, but basically industry, we are a regulated industry, and we're successful being a regulated industry. We have interest in a strong and consistent regulatory environment. So I think we're not as different in our views as all that. I do think the white paper sets out the problem really well, and the problem is that there is a significant gap between the label and the practice of medicine, and there's a huge amount of information in that gap, and companies have a lot of it for the reasons that many people here have said. There are products, we're very familiar with them. We have, admittedly, an interest in communicating that information, but with all that, we do have a lot to say. And I think the white paper also points out there are significant changes to the healthcare environment since these regulations were established. There are a lot of other different parties involved. They are really active, strong patient groups who are interested in active in seeking information. They're payers, accountable care organizations that have varying interests in this stage. And lots of people are generating and talking about information, and manufacturers, again, are one of these parties, and they need to be an equal party at the table. There are changes to the legal landscape, and they've been mentioned already with the cases that are really pushing this issue to the fore. And the question that I think we're all struggling with is, how do we evolve this regulatory system so it's responsive and so that the FDA is leading in this area and not trailing in this area, which I think is where it currently is. If I were to look at the principles, I was going to do the same thing Josh did, talk about the principles and the proposals. The first one, which is supporting FDA's central role in reviewing and approving new, it talks about claims. I would say slightly different, that it's really important to support FDA's central role in reviewing and approving new products and new indications. Claims is a different matter. That's really FDA's central role in approving anything that's said about a product. And to quote an old case, that may be exaggerating FDA's place in the universe if it's viewed in this way as being the arbiter of what's truthful and non-misleading. So I think there's a room for communication, and FDA doesn't have to be the center of all communication, but it is absolutely critical for FDA to be in the role of looking at and approving new products and new indications. Definitely agree with the need to coordinate agencies in this regard. I think, Mark, I think you mentioned that it was really people looking at OIG as the significant player in this space. And frankly, prosecutors don't make very good regulators, and prosecutors don't make policy. Prosecutors' interest is in settling a case and extracting settlements, not in making good policy. And I think we're not in a good place right now when the industry is focused more on OIG than on FDA as a regulator. I also agree that litigation isn't an answer to regulation. And Josh, you'd mentioned the Ameren judge, at the back of that opinion making, looking at the claims and parsing the wording of claims. And it is a funny thing to see a judge doing that. And I agree, it's probably not the best way for the system to run. I think it's sort of a sad consequence of the fact that FDA is far behind and completely out of sync with the current legal standards. And so court companies have struggled with FDA and then turned to the courts in a couple of situations, and then you end up with judges parsing this rule. So again, I think it's really critical to get FDA back in front and in sync with today's legal standards, and I think we won't be in the courts with these issues. I agree also with the principle that it's important to drive evidence generation. I think the big question is, what would drive evidence generation? So, for example, I know at our company, it's not infrequent that someone comes up, we have this study we'd really like to run. And then the question comes, well, will we be able to communicate the data in any meaningful way? And unless you can run 2 well-controlled, adequate clinical studies, you may not be able to put it in the label, you may not be able to speak to it under FDA's current interpretation of their regulations. And, a lot of times we just put that study aside. We won't run that study. And so does forcing everything into the label, through the label, drive evidence generation, or does it work against evidence generation? I think it's something that we really have to think about. So turning to the proposals, guidance, regulatory guidance is the first thing on the table. Honestly, industry has concerns about guidance, and I think the concerns are that it's not binding. And frankly, much of the guidance we've seen from FDA has not been that helpful. It addresses the pretty obvious questions, really doesn't address the subtle questions, and doesn't move us very far along. That said, I absolutely recognize that guidance is a much easier tool for the agency to use. It's more flexible, and it really has some advantages in that situation, in that respect. I would say if we're going down that path, I think the thing that FDA really needs to do is get guidance out quickly that's broad and gets the agency largely in sync with the law. My concern is we'll get dribble, drabble, piecemeal guidance, and it really won't answer the questions. It won't satisfy the concerns, and we're going to end up with more cases like Ameren and Pacira. it was interesting, Colleen, to mention that you guys first sat down, thought you'd come up with a unified proposal to solve this all, and then backed away and realized we're going to have to end up with some principles here instead. I think it's a struggle that every one of us who's dealt with this issue over years has had, and I think we all want a unified field theory of this communication issue, and I think it might evade us. And perhaps guidance is a way that can be more flexible, that the agency can really look at significant issues about off-label, true off-label, like brand new indications versus information that's related to approved indications, and do they treat them the same? Do you treat communications with payers the same as you treat communications with consumers? Do you look at promotion and scientific exchange in the same way? And what are they? Josh, you mentioned promotion as a company trying to sell its product, but I think there's a huge range of communication that companies do, from direct-to-consumer promotion to medical information services, and I think the same standard should apply. Revision to efficacy claims. It's interesting, when I think about this, certainly in oncology, and Genentech obviously does a lot of oncology, the review division is incredibly flexible in how it considers and uses evidence. So they've based new approvals on 2 well-controlled adequate studies. We've had indications based on retrospective subset analyses. And that same flexibility really doesn't show up on the promotional side, or to the extent it shows up, it's a flexibility that FDA wants to reserve to itself. So it will be flexible, but only on its own terms. And I don't think that's long-term sustainable. There needs to be flexibility in the information underlying claims. And I think what's really important is then to be transparent in what those are. What is that claim based on? What are the limitations of that? Maybe it's grades of evidence, maybe it's other things. I just think that in the end, it can't simply live with FDA to determine those for itself. Don't really have too much time to talk about the third-party concept. So Josh mentioned, do you want to set up a parallel agency with FDA? And I have some hesitation around that as well. I also wonder if centralized control of information is a bit of an anachronism in our information age. Would we be better off setting off standards? What is truthful and non-misleading? What disclosures are required, as opposed to running every single communication through a third-party entity? So I think I'll leave it at that.
Great. Thanks very much, Michael, and again, both of you for the thoughtful comments. Clearly read the paper closely in a short time frame. I'd like to first go back to our other panelists to see if they have any quick reactions to the comments they've heard. I'm going to keep these brief to enable us to keep moving on to the rest of the discussion.
I think just briefly, I think maybe a word that's better than clarity is leadership. When you look at Ameren, we've moved from from snake oil to fish oil in a certain fashion. When a judge is struggling to find reasons to grant Chevron deference and just can't, you ask the question, has regulatory ambiguity backfired, and allowed a judge to say, well, lacking any guidance or even draft guidance, I'm going to assume that the promotion of dietary supplements is the same as prescription drugs, and make my ruling. Whether or not the lack of more formalized guidance from FDA was on purpose to keep ambiguity, or simply didn't rise to the level of the most important thing to do, it's clearly been usurped, and it's time, I think, for the FDA to regain control of that conversation before it really gets out of control.
Yeah, and 2 points, and just excellent observations, and the scope of the issues that are highlighted is comprehensive. One, on judges taking over, I understand the point you're making. Certainly we're lawyers and not physicians, so we don't mind that. But the point here is that in that kind of litigation, there are so many rounds that FDA is really in control, to the extent that it's having settlement discussions and, fines, lines. Nobody likes to litigate. It takes forever and it costs a fortune. The one thing that I would observe is where the rubber meets the road here is in the labeling negotiations as part of NDA or BLA considerations. And to the extent, there's a lot of leverage that FDA has in that. It's taken a long time for review. It's been very expensive. Companies want to get the product on the market in some form. So, to the extent that labeling negotiation kind of does observe the practice of medicine or other studies, whether submitted or not submitted, they should all be submitted. Ideally, if there is a expansive view there at the table with all the parties and a label is broad enough, that could remedy some of the pressures that are existing in the marketplace.
I have a series of alerts set up for various sources of stuff that I track, and one of them is an alert that enables me to read everything Dr. Sharfstein has ever written. So I'm going to roll the dice and see if I can.
You and my mom.
Right. How is she? So I'm gonna try to encapsulate what you've said, and I know you'll tell me if I've screwed it up. But I think this is incredibly important because one of these things is not like the other, and I think there's a real risk of sort of this turning into a ships passing in the night conversation, which I desperately don't want. So if I'm tracking, you're saying, I think that manufacturer speech, because it's economically motivated, is by definition promotional. You're saying, I think, that manufacturers, because of that profit motive, can't be trusted, and patients have historically been harmed by off-label promotion. It doesn't make a whole lot of sense for a lot of institutional and other reasons to have a new section of labeling for emerging efficacy and other information to be made available to physicians and payers and patients. And it's not a great idea, and I think Michael had different reasons for coming to the same conclusion, not a good idea to have a third-party mechanism, because I think, if I heard you correctly, it sort of undercuts one of our guiding principles, which is that FDA really ought to be the primary source of adjudication of emerging data for inline products and for other data. That to my ear sounds like maintaining the status quo is where you are. And the thing that concerns me from a policy standpoint about that is that the litigation itself tells us that the status quo is not tenable, in addition to changing societal expectations that Eleanor Perfetto talked about, clinical expectations that Rich talked about, payer expectations that Ed talked. It just sounds like the advocacy on the other side of this conversation is maintain the status quo. And if that happens, what we're teeing up is a game of chicken with the public health, in which judges do increasingly issue orders sanctioning particular forms of communication that you might not agree with and that might not actually be great for the public health. The worst case scenario is one that we haven't yet seen in litigation, which is a federal judge entering an order that FDA will be required to follow, dictating what FDA can and can't do in this area. We had that in WLF and it went away thanks to Bill Schultz's, amazing lawyering, but it could happen again. And what I would love to hear on all sides is an effort to identify what's next for FDA. How do we keep FDA in the game? How do we make sure FDA isn't just rendered irrelevant in this conversation? We all agree that FDA needs to take a leadership role, is the leader, is the acknowledged, the premier public health agency in the world, and I'm very concerned that the alternative perspective, which is an incredibly important one, to call it alternative doesn't do it justice. This important perspective that you're articulating, I am concerned, doesn't leave any room for FDA to change, to address all of the factors in the external environment that are changing around it.
Thank you, Mark. Do you mind if I just do a very small?
If either of you has a response to that, please.
Yeah, I appreciate all those comments. I would say that my position isn't exactly that manufacturers can't be trusted, but that it's an empirical question, the extent to which an economically motivated manufacturer sharing information is good in the end for patient care, that I would expect to see evidence on that. I'm aware of evidence that suggests it could be a problem. I think that it's not something you can accept on faith. That would be my position, not that I don't believe in advance that it could never happen. I think that there's a cultural divide here that and maybe that points to a potential way to bridge the concern that Colleen is raising. And let me just say that I mentioned my mom, but I actually do know her dad, who is a great guy. He works in the state of Maryland for a long time. And he is so proud of Colleen. Every time I ran into him, he's was for a long time one of the senior advisors, I think, to the Maryland comptroller. Is that right?
He loves you
Well, okay. Well, he is a great guy. He helped us a million ways in Maryland. So, what I was going to say is that, I am a physician. I don't come to questions of what judges do like it's just is what judges do. I look at it and say, the judges are changing. The judges are doing these things, and partly we can talk back and say that that's a very dangerous course for the judiciary. I don't view it as something that is totally happening, and there's nothing that we, there's no way to engage with it. And I wonder whether if you were to say, like, okay, I did say I agreed with the idea of clarity. FDA should be doing what it, has promised to do in certain settings and be very clear on guidance. But at the same time, if FDA does that, we're going to ask the judges to respect that. We're not just going to wait and see what happens. That the industry can come together and say, we want clear guidance and we will respect the FDA's role because we think it's important. Because the flip side of that is there will always be people who are going to challenge it. And I don't think that what's going on with the judges is just a matter of lack of clarity, but with FDA, if you look at, my reading of their decisions as a non-lawyer is that there is a very ideological view about speech that's sweeping through a lot of different court decisions, and taken to its logical extent, it does have all these, very serious ramifications for FDA. And it's not enough just to talk to FDA and say, do your best, when at any point the court can come in and everybody's reserving their right just to complain about every individual case. And maybe the coming together here is FDA should step forward with a clear proposal, and people should really kind of close ranks and say, we will debate FDA on its proposal, but we will defer to FDA on its decisions, because in the end, that's what makes a powerful regulator, and as we heard, that ultimately what supports a strong industry.
Add one quick thing. We're supposing that the three court cases are in some way definitely causing a rethinking, sea change inside the FDA, and I hope that's true. But there's an alternative scenario here, which is, where are the big guys? I haven't seen any court cases from this large multinational company or that large multinational company, so we will continue to expect people to roll over and do what we say. That is a very entrenched psychology that's going to be very tough to dislodge. And I think that by allowing the agency to take small steps forward with the momentum, Josh, that you mentioned, is not going to put the agency back in control, and it's going to allow judges to continue to create policies that are not either scientifically balanced or in the best interest of the public health.
Well, I would like to come back to this issue of reaffirming FDA leadership, which I see a lot of head nodding for and a lot of comments come back to that. But Michael, you had a quick reaction.
Just a couple of thoughts, which is whether the economic incentives of companies renders them sort of unable to provide objective information. And I'd raise 2 points with that. One is, we're not the only party in this discussion that has an economic incentive. Physicians do. Payers do. And money is not the only source of bias. So there are a lot of people who have ideological or their own scientific biases. And so I think to just call out the bias of industry is sort of missing the larger point. And another thing I would add is industry is already viewed as being able to provide truthful and non-misleading information. So FDA already permits companies to provide responses to unsolicited questions. And so it's not less truthful in that context than in the promotional context. So, I think, which is not to say there's no bias and that there's no issue there, but I think it's shouldn't be overstated, and there are ways through disclosure and through other means to address that issue. I don't think if
I don't mean to overstate it, but I worked for an investigative committee of Congress. I've read the thousands of emails. There is such a thing as deliberately distorting information for physicians. It
absolutely
exists. You can point to it, and so all I'm saying is that in thinking about the right way to regulate in this area, people should be cognizant of the evidence that exists on this. I'm not saying it's not possible for companies to.
And I think that's fair, and I would just argue that they're going to be bad actors whether the law permits or doesn't permit something. And I think there's another thing too, is there's a concern, and you've expressed it, and I think others express it as well, which is this real concern about the damage that can be done if harmful information is conveyed. And I think that is true, but there's also real harm if valuable information is not conveyed. And I think the debate is so slanted toward the precautionary principle of not letting anything problematic slip through that we often miss the fact that a lot of valuable information is not making its way out to people who could really benefit from it.
It would help me to understand an example of that. So scientific communication can happen, all the publications are happening, all the medical groups are communicating, but there's something that the company itself needs to be providing, or there's a gap in information. Can you just help me understand that kind of scenario?
Well, I'd say, I think Dr. Shilsky mentioned this, which is that physicians, there are a tremendous number of information sources, and they don't read the label, they throw the label in the garbage. They really look to someone to come and help them distill some of the issues that are there. And that was expressed by the payer as well. They'd like to have the ability of companies to more freely come to them with information that they value, as opposed to relying on knowing and having to ask all the time. From the patient side, it was expressed that patients don't know that they can go to companies and ask companies. The information's there, but if you're relying on people knowing it's there and figuring out how to get to it, as opposed to allowing a company that does have some interest in conveying that information, then actively does convey that information, I do think you close gaps.
Also, there's a difference between a conflict of interest and an interest. Josh, to your point, everybody should be transparent about what their interests are. Companies have interests, payers have interests, physicians have interests. It's important that that's understood, and that will ultimately, I think, from a physician perspective, certainly enter into how they choose to weigh the information that's put in front of them.
This has been a great discussion, and if we have time, I'd like to come back to at least three themes that have emerged. One is this issue of evidence generation and use, which, as Josh, I think you said, look, there are pathways now for companies to communicate with lots of different groups, payers, physicians, and so forth, if they are asked. I think we heard earlier today, a lot of people may not realize that, and maybe this turns out to be like an approach where making people more aware that they can ask, and making sure this is not just like a game of Battleship where you have to go through 20 different questions to really find out what you want. Is there a way to build on that approach to generating sharing evidence? And I would add to it, I think as Michael mentioned, if there is a clear pathway to sharing evidence, then that's going to lead to more evidence generation. There's been a lot of discussion around whether the policies in this area are going to lead to a wave of more evidence emerging from real-world contexts and other contexts, or is it going to lead to a reduction in the evidence that reaches the level of the information on the label, or maybe it's some of both. I think that's a further topic that you and others have mentioned that was certainly part of the debate and discussion going into this paper, which is how could you generate more empirical evidence on whether these policies really are promoting more evidence and the public health. I think that's what led to some of the proposals in the paper about maybe starting with some pilot areas where if there is a third party who can help assure adequate access to a range of perspectives and a full view of the information, is that an area where FDA could provide clearer guidance to promote off-label communication, or in the area of new kinds of contracts where the payers are reimbursing not based on volume of drugs sold, but based on results for a patient population in terms of getting costs down or improving outcomes. Is that an area where maybe a start at this expansion of communication with clear guidance from FDA could take place? But I think the other theme that's come up is the importance of FDA leadership in this area, and this is a hard one. As I take away from the comments that have been made, everybody agrees about FDA leadership on drug approval and labeling. But when it comes to managing what Josh characterized as a very large and diverse set of information, what Michael, you characterized as claims rather than label information, clearly this is very relevant to decision making, and clearly it's an area where a lot of legal cases are taking place now that seem to be, from what all of you are saying, undermining the authority of the FDA. So for more FDA leadership in this area, this is where some of the proposals in the paper around things like having clearer standards or having more of an FDA role in guidance, either through a third-party organization or through these other information aggregators, could potentially be helpful. But clearly a challenge to get FDA back into a leadership position. I think everybody on this panel agrees is important step to address. So I do want to leave a few minutes of time for questions. Josh, it looks like you want to say something.
I had a question
while
for
Josh
you.
While Josh is saying
you,
something,
yeah.
I'd like to ask people who do want to make comments to come on up to the microphone.
Sure.
So.
Did you consider in your third-party idea the idea that the third party would be doing the communication, as opposed to the third party would be authorizing the company to do the communication? In other words, there would be a third party that could collect all kinds of data and then independently, put it in a way that could be accessed, rather than the third party authorizing the company. So the third party thought, this is a really important point that the company's making, then, that's really important for clinicians to know, as opposed to the third party just giving the thumbs up. The thumbs down.
I think there are a lot of third parties now that sort of do that. So the
what's the failure of those third
guidelines
parties, if you consider
and
that?
I think that
guess
gets back to this. I think maybe this is the nub of the issue around how communication to those third parties could work more effectively. Whether it has to be questions from the manufacturers, or whether there's a more active framework to promote the effective use of those third parties
really
and the evidence.
They can ask questions to the manufacturers to get the data. I don't quite understand. I'm just, to me, that among the third party options seems a little more intuitive.
Let me ask if other panel, Colleen, Mark, comments on this.
I want to hear what other people think.
Okay, great. Let's go to the questions from.
I'm John Stone with Energy and Commerce, and God bless you for just having this conversation. I think it's incredibly important. I'd like to focus on just one subset of issues here, and there's a number of well thought out ideas in here. I think, as Josh indicated, it seems like there's unanimous support for additional need for clarifying these these key concepts and terms. My question, though, is, and we haven't heard a lot about the Fifth Amendment issues. We did hear about the anecdotal evidence about, DOJ saying things that FDA is, an hour later contradicting, and the fact that judges and prosecutors are making policy. Just clarifying these terms and guidance, is that going to address those Fifth Amendment issues? Is that going to address those inconsistent interpretations, or just, DOJ and OIG ignoring them? Because, well, first of all, I'd like to hear your thoughts on that.
Colleen or Mark for that? Yeah.
So the
Microphone.
The Fifth Amendment principle basically is that, particularly in where speech rights are implicated, the law must be clear. There have to be concise a priori standards that regulated entities and speakers can use to determine in advance whether what they're proposing to say falls on the prohibited side of the line or the permitted side of the line. And the First Amendment issue here with the lack of clarity is obvious. If you're a manufacturer and you're trying to navigate the web of interlocking and overlapping and superseding guidance documents and regulations and statutes and court decisions and underlying principles, it's virtually impossible for you to identify those clear a priori standards, and therefore the whole scheme is be set by not just a First Amendment infirmity, but also a Fifth Amendment infirmity in this lack of clarity. And this is something that we've, through the Medical Information Working Group, have engaged with FDA on. And in June 2014, FDA responded to a couple of citizen petitions that the MIWG filed and acknowledged that the Fifth Amendment was on the table in terms of the agency's efforts to provide additional clarity in these safe harbors. To your question about guidance specifically, this is my own individual view. I do not think that guidance is adequate to satisfy Fifth Amendment requirements for clear a priori standards. The way guidances get generated in itself raises a very serious Fifth Amendment issue. You don't have reg writers writing rules that are codified in the CFR. You have a lot of different cooks in the kitchen writing a paragraph here, a paragraph there, describing their current thinking on an issue. It's very, very subject to interpretation. And you have the added problem that you identified, John, of not everybody outside of FDA, and indeed not even everybody inside FDA, kind of buying into the norms represented, or arguably represented by the guidance. And on its face, it's not binding, and by law, it can't be binding. So there are a lot of problems with FDA's use of guidance in an area like this, where you have not only First Amendment considerations, but Fifth Amendment considerations.
Mark, very quickly, I want to
Just
get to the other
two
questions.
really
yeah.
quick points. One, there isn't a proliferation of litigation in this area. There are just very few cases, and the courts have been surprisingly consistent in this. You know, if it's lawfully marketed and the communication is truthful and not false or misleading, kind of you can make it, as long as off-label use is legal. FDA gets to decide what's false or misleading, and that's a huge area. The regs in that area, you know, 201 and 202, labeling and advertising, haven't been updated since the 70s. You know, let's rule make, and then we eliminate it. And those guidances, those regs, could use a little clarification and updating in the technological revolution that we're finding ourselves.
Next question.
Before I get, let me just make one comment. I mean, as several of you know, I mean, we remain ready and willing to help FDA stop the bleeding. And I think for some of the very issues that folks raised today, in order to do that, and in order to stop judges and prosecutors from making policy, we do need constitutionally grounded parameters in statute. We have proposed those before. We remain eager to help the cause. So thanks again for
Thank you very
hosting
much.
this.
Thanks.
Goldkind. I was former acting division director at the FDA and associate professor of medicine at the Uniformed Services University. Thank you all for a terrific presentation and dialogue. This has really been top-notch. I thought all of the positions in the paper were compelling and thoughtful, and nodded at all of them. And then as speakers responded to them, I have to say, looked at the other side of the coin. What strikes me is that if FDA has to be at the center of this issue, and the status quo isn't acceptable, then what are things that the FDA can do to respond to the explosion of information, much of it important and meaningful, and yet live in a universe where promotion in the sense of advocating more use as opposed to important information dissemination. Not that those are mutually exclusive, but with the goals, as Dr. Sharfstein was talking about, public policy. Right now, the paradigm at the agency, is the label. It's all about the label. What goes in the label, what doesn't go in the label. What's the standard for that? And if something is not in the label, the reg doesn't state anything of any potential value must be in the label. But the information necessary to use safe and effectively. Now, that is what people look at, and I think the paradigm for what is valuable and important information needs to expand some. So it isn't tenable to be changing the label every time there's some article out there or something new develops. That's a slow process. On the other hand, the FDA, I think, is going to have to start making judgments for when to consider something false and misleading simply because it is not in the label, and some alternate approach where, in a sense, it wouldn't be a CBE or a supplement to change the label, but in a sense, a query of the division and ODPD to say, this is data we're submitting. Do you consider this to be in conflict or false and misleading? And so that a silence doesn't change the label. It doesn't mean the FDA is putting its stamp of approval on what's being said, but that it isn't going to say this is, that this is unacceptable, or that we will consider this false and misleading. I think that is, that is going to require working. I see
You're gonna
Dr.
have-
Sharfstein.
You're going to have a lot of emails in your inbox.
Right,
You know,
I-
asking for that. I think there is a real practical problem with a lot of these things, which would require the FDA to do a lot.
I agree, and it would have to be massaged. And so the FDA can't get, 50 requests from every company to tweet, can I do this and can I do that? There'd have to be a bar set. It would require some guidelines. But I think that kind of an approach has more potential than saying go outside of the FDA, or the FDA is going to have to radically change in ways that you, Dr. Sharfstein, said we
appreciate
really
these
shouldn't.
efforts. So here's what I'd like to do. We've got 2 more comments I'd like to get to, and then maybe brief closing remarks from you all. We are very tight on time, and I appreciate that comment, like many, about what to do with this large and maybe growing middle ground that's between unfounded statements, as you were saying, and ones that make the label. Yes, Rich.
Rich Shilsky. So I just wanted to come back to sort of the guiding principle about protecting the public health in the sense that, there are several ways of doing that, of course, and they all rest on the FDA's guiding philosophy of assessing risks and benefits. So you can protect the public health by protecting people from being exposed to risks that are inappropriate and dangerous and untenable. You can also protect the public health by enabling people to have access to therapies that are going to benefit them when they have no alternative. So, it's the whole risk-benefit conundrum all the time. Dr. Sharfstein, you asked for an example. I don't know if this is the kind of example you were looking for, but, consider the new class of drugs in oncology, generally known as immune checkpoint inhibitors, okay? So there are 3 of them that are FDA approved. They're FDA approved across 3 different diseases: melanoma, lung cancer, and kidney cancer. But there is a list as long as your arm of tumor types where these drugs clearly have efficacy. Is the efficacy so well established that it might, rise to the level of, several prospective, well-controlled studies? Maybe not yet, but it's coming. And every oncologist knows this, and every patient knows this, and these drugs are going to be so widely prescribed, it's not even funny, because there doesn't seem to be any tumor type where they don't work. So the real, the question sort of comes down to, well, the commercial sponsors of these drugs have a tremendous amount of information about these drugs that is rapidly developing, that's not in the label, that doctors would benefit from hearing from in an organized way, that patients would benefit from hearing about in an organized way, and those sponsors can't communicate it. And it just seems to me that we have to work toward a mechanism by which those sorts of communications can go forward. I personally struggle with this issue about we're going to create a lot of extra work for the FDA to review more and more kinds of information. Seems to me that's what they're supposed to do. And if it is going to require extra work because there is more information, it is more variable in quality, and they're clearly going to need more resources to do it. But if we're going to rely on them to be the independent adjudicator of the quality of the evidence, then they have to be resourced to be able to do that.
Thanks, Rich. Last 2 comments quickly, and then I get closing comments from the panel very quickly.
Sorry, Danny again from the Gray Sheet. So going back to my earlier question about how this affects the medical device industry, if you guys would comment on that. And secondly, I wanted to quickly ask, in terms of creating a 3rd agency, was the reasoning behind that because of resources that FDA might not have to be able to oversee these? And if that is the reasoning, then where would the resources come from for a third-party agency, as you guys have kind of proposed here?
Okay, good questions, and
I had a lot of comments, but I'll be very, very brief. My name's Ruth Lopet. I'm from George Washington University, but in the interest of full disclosure, I'm the former Chief Medical Officer of the Australian Therapeutic Goods Administration. I wanted to congratulate Dr. Sharfstein on his comments because I thought it was really helpful to put in context the need to consider the history and the reasons why off-label communications, off-label indications have not been allowed to be subject to promotion. I think one of the key points I would like to make is about the quality of the evidence that's collected to support any off-label communication. And I actually think there is an ethical obligation that if you prescribe a drug to a patient for whom the clinical trial, who is outside the context of the clinical trials reflected on the label, that you have an obligation to collect data and to do it systematically. And I would argue there's an analogy here to the use of the only in research classification that the National Institute for Health and Clinical Care Excellence uses in the UK in allowing some drugs to only be used in the context of systematic research. So my view is that if you're going to allow off-label communication on off-label indications to be promoted, then the data that supports it has to be collected systematically and not haphazardly and not through data mining and not through post hoc retrospective subgroup analyses, which send chills down my spine, frankly.
Thanks for the comment. Certainly better incentives to support the creation and development of that evidence was a key principle for this whole effort. So I really appreciate it. Let me go to...
One final quick question that puzzles me is that I worry about the reduction in incentives to submit supplemental NDAs. And I also worry about if a supplemental NDA is submitted and rejected, what happens then to that information?
Great set of questions. We are out of time. I'd like to ask our panelists if they have some one pithy Twitter-length comment that they'd like to make, and remind people that this is certainly not the last word on this effort. It's not the last word from this group. What we were hoping to do, I think we achieved with this public meeting, was to raise some ideas, some principles for a potential path forward, and get some very useful feedback and perspectives on where to go from here. So more to come on this important issues. And as I mentioned earlier, already did sort of a mini summary. I think there is some common ground, some very good ideas that have come out of this to move forward. So I'm going to go down the row for just very brief final comments. Peter.
Quickly, nature abhors a vacuum, and unless FDA steps up to the plate to lead this conversation, to look to outside advisors to help it formulate its viewpoints, I think we're all going to be sucked into a very unpleasant vortex.
Yeah, two questions. One, on devices, not to ignore you. It's to quote Donald Trump, is kind of a disaster over there.
Huge disaster.
Huge disaster.
All of which is off-label right now.
There isn't enough being done. 510Ks and some interpretations don't need to have contraindications or contraristic information. Device companies are going direct to consumer in a very confusing way, and there needs to be more done, and everything's bootstrapping onto what would CEDAR do in this, or OPDP. The comment on the CBE or some supplement that would make it easier to get information on the label, maybe not with the same substantial evidence standard. It's a great idea. It needs to be done. FDA seems to be creative enough to and I don't want to criticize FDA because they're doing such a great job in such a hard environment, but they're saying warnings, in the feedback from the Wyeth decision and others on safety warnings, that for generic companies or others, you should have a streamlined way of getting the warnings on the label. You should also have a streamlined way of getting efficacy information or clinical trial information on the label, that's all.
Thanks for answering the questions, Sue. Colleen?
We did have devices in mind when we did the paper, so everything in the paper in principle applies to devices. If you have specific questions, I'd be very happy to talk to you offline.
Great, thanks.
And on this question about SNDA, I mean, obviously everybody likes the idea. I mean, data are like apple pie. Who doesn't want more? But the constitutional problem that you run into is you can't hold anybody's constitutional rights hostage to our desire to have more data. So, and whether you like it or not is a matter of policy. That is the answer that the First Amendment hands us, and that's why we desperately need to move to a conversation about what's next rather than getting bogged down in what happened in 1962. Thalidomide is not an off-label example. Terrible, horrific public health problem, but does really not have anything to do with what we're talking about now. Very, very different world. So I totally take your point and would love to talk to you more about it, but we need to fast forward.
Great. And we do want to facilitate more of exactly this kind of dialogue, so thanks for bringing up the question. Josh.
Thanks for Twitter-worthy comment. I'm at Dr. Josh S. You can join my mom and possibly Colleen's dad and following me on Twitter if you want. They're turning out the lights here. I think we might disagree.
There is a message in that, maybe.
We might disagree on the thalidomide example, but what I would say is that it's as important as it is for the FDA to step forward and be clear in what it thinks. It's very important to send the message to judges that they're playing with matches. And by rethinking the FDA's perspective, by taking over the scientific functions, they're risking a true public health calamity. And if that isn't part of this discussion, then FDA won't be able to draw the line. That I'm actually, I think, giving a path in part for FDA to feel more confident stepping forward if they believe that they will have support against a train of judicial decisions that really is fundamentally risky for public health.
Michael.
Yeah, I actually agree a lot with Josh in that respect, and I think the reason we have this is because of the void, and I think we have the void from FDA, and I think we have a void really on the Hill and in legislation and regulation, and I think particularly, and thanks for your comments, it's really important this issue not be viewed as a partisan issue. This isn't a Democrat or Republican issue. This is a relevance of FDA issue, and Colleen expressed with great passion this view that FDA needs to be relevant, and I couldn't agree more. And I think it's really important for FDA and Congress to make sure that happens, so that judges are not in the position of reviewing claims.
And that's another area where there seems to be a lot of agreement. This is a critical topic for further action. I do want to wrap up now by thanking all of you who came and participated in what has been a great dialogue, where we are going to be following up on this topic, hopefully with even more active engagement from the people on the stage and the people in the audience today, and that includes those of you who are joining us on the web today. The white paper, the webcast will be on our website at the Duke Margolis Center soon. This is a work in progress website. We're just a new startup in the past month here in Washington and at Duke. So stay tuned for more ways to connect with us and more ways to hear about what we're doing. Before I do wrap up, there are several people I want to thank for making this paper and the event and the discussion around it possible. I guess I got to start with Colleen and Josh's parents for their excellent contributions, however indirectly, to the discussions today. And sure, there are a lot of other proud parents around as well. Then I want to thank the esteemed speakers for taking the time to share their perspectives, to think about these tough issues and help find a path forward in a complex area. Also, a special thanks to the working group. You see them all listed. A number were here today. Their insights, their discussions, their debates, even a meeting during the blizzard were very memorable and valuable contributions to this effort. So in addition to Rich, Colleen, Mark, and Peter, whom you heard from today, this also included Jeff Allen, the Executive Director at Friends of Cancer Research, Nick Bagley, Professor of Law at University of Michigan, Amy Rick, President and CEO of the Food and Drug Law Institute, and Joy Liu, a partner at Ropes and Gray. Last, I want to thank the staff of the Duke Margolis Center, including Serena Coates, for letting me go over a few minutes here. Morgan Romine, who did a tremendous amount of work to pull all this together. Joanna Klatzman, who helped organize our event. Christina Flores and Greg Daniel, who couldn't be with us today. But you'll be hearing from us more, and hopefully in collaboration with all of you on these topics. Thank you again for joining us, and please enjoy the rest of the day. Thank you.